Hello everybody. In this video, I'm going to be sharing with you the most recent policy updates from USCIS. We're going to talk about when and under what criteria you can expedite your case. We're going to talk about new changes to their policy with respect to issuing requests for evidence and notices to deny cases. Big changes are coming in that area. We're also going to talk about the new policy to issue work permits, EADs, for a period of 2 years for certain adjustment of status applications. Next, we're going to cover the USCIS LockBox Filing flexibilities. A lot has been changing in that area, and I'm going to make sure to update you in this video. And finally, I'm going to tell you what I've learned at the American Immigration Lawyers Association annual conference that took place last week. There's a lot of information that was revealed about USCIS, some of their upcoming policies, and some of their upcoming changes that you're not going to hear anywhere else but on our channel. So what are you waiting for? I'll see you on the other side. Hello everybody, and welcome back to our immigration channel. This is a place where you get the most up-to-date immigration information, immigration updates, and everything else that you need to make your immigration journey less stressful. My name is Jacob Sapochnick, and I'm an immigration attorney located in San Diego, California, and we help clients in all 50 states. And in this video, I'm going to go over all the changes that are happening right now with USCIS, lots of interesting things, and we're going to break it down into different sections. So let's start first of all with the most recent policy updates that are coming from USCIS. So let's start first with expedited processing. Under the most recent update, U.S. immigration officers are given further guidance as to when and under what circumstances they can expedite cases. Remember that under the Trump administration, it was very difficult to expedite cases, and in fact they narrowed down the criteria as to who can qualify to expedite their case. And now under this new policy, it has been expanded. So for example, the criteria of emergency is back. That was eliminated under Trump. So now under certain emergency circumstances, you can request your case to be expedited. Also, what is coming back is the criteria for travel for medical reasons. So if you need to travel for medical reasons, that could be also a reason to expedite your case. In addition, severe financial loss. If you're going to experience severe financial loss because your case is going too slow, that can also be a reason now to expedite your case. Again, all this was eliminated under the Trump administration. And finally, if your case is pending, and as a result of that, you may need to lay off employees. If you're an employer and you're waiting for a petition and it's taking too long, that also could be a reason to expedite your case, and it's going to help a lot of employers that are currently waiting for their work visas to be processed. And if they can show that, listen, we're waiting for this employee, it's been almost a year, it's going to cause financial hardship, and we're going to need to start laying off employees. So these are kind of the reasons that now we can use to try to expedite cases, whether it's employment-based or family-based petitions. And finally, nonprofits that request that their expedite request is in the interest of the social and the cultural benefit of the United States, they can also request their cases to be expedited. So overall, this is great news, more options for us to expedite cases with USCIS. Before we jump to the next section, remember, if you're here for the first time, don't forget to subscribe to our channel, click the notification bell so you don't miss any of our videos, and also give us a big like so YouTube will be able to show this video to more people just like you. If you need my help with any of your cases, make sure you send us a text, 619-483-4549. Now let's jump to the next policy update. Requests for evidence and notices of intent to deny. USCIS is now rescinding its 2018 policy memo that essentially allowed them to deny cases if they were missing certain initial evidence. So for example, let's say you file your green card case, but you forgot to include a birth certificate or even a marriage certificate. Under the old policy, 2018, your case could have been denied without issuing a request for evidence. Well, now they're canceling all that. They're going back to the 2013 policy memo. And out of the memo, if you file a case and the Immigration Service is lacking certain evidence or they have questions about whether you're eligible, they should send you a request for evidence, request to clarify what's going on, and give you an opportunity to provide that evidence. Well, all this is coming back right now. It's going to help ensure that our immigration system is fair and reduce the amount of cases that are being denied for no reason. So this is overall great news, and we're excited to be able to help our clients even further without getting unnecessary denials that not only clog the system with motions to appeal and requests to resubmit, but also makes the whole process much more fair and reasonable. And the final policy update is the USCIS is now extending the validity of certain employment authorization documents, specifically in cases involving adjustment of status. Essentially what they're going to do, they're going to increase the validity of the work permits that you file with your adjustment of status application from 1 year to 2 years validity. That includes for new work permits filed with adjustment of status, including extensions as well. Overall, this is great news that's going to help reduce the backlog. Less people are going to need to file applications more frequently because they're going to be extended for 2 years. Current backlog is more than 370,000 EAD applications being filed in 2020, and the backlog keeps increasing. So by doing this, they're going to reduce the backlog and allow people not to worry about losing their jobs if their work permits are now expired. Now let's move on to the most recent update from USCIS, LockBox Filing Flexibilities. USCIS is going to offer some relief and guidance to those applicants impacted by the severe delays with the LockBox filing. As you remember, when you file cases like DACA, N400, adjustment of status, I-90s, and certain I-360 self-petition cases, it took the LockBox more than 11 weeks to even issue a receipt notice, and in some cases even more than that. The problem was that by the time they ended up adjudicating those cases, the filing fee checks expired, and they had to resend those cases back, rejected to the applicants. In many cases, it resulted in people overstaying, aging out, and many other things. So this recent guidance gives us an indication what's going to happen to people that were impacted by those rejections. So this is what the guidance say. The first one is regarding fee waivers and rejected applications. So your adjustment application, your N400, your I-90, if that application was rejected just because your fee expired, but your benefit kept being processing, so they didn't reject your entire case, they just send you a notice that your payment expired, under this guidance, you can resubmit your application with a new fee, and they're not going to penalize you for late filing. If your application was entirely rejected because of the delay, so for example, they rejected your N400, they rejected your adjustment of status because of the delay, they will consider your application as if it was filed on the original date that you submitted it, and they're also going to waive your fee. And you can just resubmit the application without a fee as long as you can prove that that rejection was only because of their delay in processing your case. Another flexibility with the LockBox is the child age protection. So for example, if you submitted your application and it was pending, and because of their delays, your check expired and they had to send this all application back to you, whether it's an N400 or an adjustment of status, and by that time, if you were under the age of 21 and then when the application was rejected, you were over the age of 21 and now you're missing your benefit, if you can show that this rejection was because of the USCIS fault, because of the delay, you can now resubmit this application and they will honor your age at the time of the original application. And so this way, people that lost their benefit because they age out because of USCIS delay are going to be able to resubmit this and still keep their benefits because it wasn't their fault. Finally, USCIS encourages applicants to check their petitions that were rejected in the past year and see if they're rejected incorrectly, and if so, contact USCIS and try to figure out a way to refile those applications so you can still maintain your benefits, specifically in people that are concerned about their priority dates. So it's really important to know that some people, when they file an application on a particular date, that date becomes their priority date. And if the case has been rejected, they have to start all over again. Well, if you can prove that it was an error of USCIS, specifically the LockBox, you're going to be able also to retain that original priority date before the rejection. So make sure you look back at your cases that were filed from October 1st, 2020 to April 1st, 2021. Any rejections from the LockBox that were done incorrectly can now be resubmitted without any penalties, which is amazing. If you need help with any of your rejected applications, don't be afraid to send me a text, 619-483-4549. I'm here to help. And finally, I wanted to share a few nuggets, a few updates that I learned at the American Immigration Lawyers Association annual conference that took place last week. We attended a few open forums with USCIS, with many other agencies, and here's a few things that I wanted to share with you. At the USCIS open forum, representatives of USCIS clearly stated that interview waivers will continue to happen. These are interviews that are being waived specifically for applications that are based on adjustment of status, both on the employment and on the family side. They confirmed that such interviews are going to continue to be waived. The thing is, there are no criteria and no guidance as to what they're looking for when they're waiving those interviews. That information wasn't disclosed, but the good news is that you're going to be able to see more and more interviews being waived with their efforts to combat the backlogs, because the less interviews they have to do, the more time they can spend to clear those backlogs. So that's a great update that I can share with you. More interview waivers are coming your way from USCIS. The second thing they mentioned is we have a big issue with people that are filing for re-entry permits and other applications that require biometrics. And specifically when you file for a re-entry permit, sometimes you have to travel back before you get your biometrics, before you actually get your re-entry permit. And it's very difficult for people to go back and forth and come back for the biometrics. If you don't show up for your biometrics, your case can be completely canceled. Right now, if you need to reschedule your biometrics, if you cannot make it, it's very difficult. You have to stand on the phone, you have to call USCIS, you have to get an agent, second-tier agent, and it may take hours. And most people find it very difficult to do so. Well, under the new proposal they're implementing, soon you're going to be able to reschedule biometrics online. There's going to be a way to log into their website and reschedule biometrics in a few minutes. So if you're overseas or if you cannot make it, all you have to do is log in and reschedule it online. This is going to be a huge help for many applicants that are currently struggling to reschedule their biometrics. The change they mentioned is that within the next year or so, almost all USCIS applications are going to move online. They're going to have no paperwork anymore to be filed physically. It's all going to be online through a new system that they're developing. Currently, there's only a few applications that are fully online, but in the next year or so, the entire USCIS form system is going to move online. So hopefully it's going to happen. I still find it hard to believe that they can implement it so fast, but that was the idea, and that's the goal for USCIS, to move the entire system online, which is great for all of us. Also, they're going to be expanding premium processing to many more applications. That was already proposed last year, but now it's actually going to start being implemented. You're going to be able to file premium processing for many applications, including change of status applications inside the United States. It's going to help a lot of people. It's going to ease the pressure, and it's going to make the system much more efficient. So premium processing is coming to many more applications very soon. So overall, these are really great updates from USCIS. Hopefully the Department of State can learn something from them and see how they are trying to improve, trying to make things more efficient, and they're trying to help the public. Even when they make mistakes, they're really trying to work on a system to make things right. If you enjoyed this video, please let me know in the comments what other topics you would like me to make videos on. And if you have any questions, also drop them in the comments. Once again, if you're here for the first time, don't forget to subscribe to our channel, click the notification bell so you don't miss any of our videos, and also give us a big like so YouTube will be able to share this video with more people just like you. Thanks for watching, and I'll see you in our next video.